3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we looked at the Israel Connection international intelligence ties. Today we're analyzing why international law enforcement failed to stop Jeffrey Epstein despite his crimes spanning multiple countries. As always, every document and source we reference is available at epsteinfiles.fm. So let us start with the Interpol Red Notice mechanism, because no red notice was ever issued for Epstein after his 2008 conviction as a registered sex offender traveling internationally. That absence is the first structural failure.
It is. It's the foundational failure. It's the silence that defines the entire decade that followed. Between 2008 and 2019, Jeffrey Epstein moved across borders with a fluidity that just seems mathematically impossible for a registered sex offender.
Right.
But when we audit the Epstein DOJ report, that's source one in our stack, the explanation is bureaucratic. It's not magic. The report confirms a comprehensive review of Interpol archives, and the finding is zero. No red notice.
We should probably verify the mechanism for anyone listening, because red notice is a term people hear in movies, but the administrative reality is it's quite specific. It's not just a wanted poster.
It's not. A red notice is effectively a global be on the lookout, but it carries real legal weight. It's a formal request to law enforcement worldwide to locate and provisionally arrest a person pending extradition, surrender, or similar legal action.
It's what makes the screen flash red when a passport gets scanned at Heathrow or Charles de Gaulle.
Precisely. It's the standard international tool for stopping fugitives. But here is the discrepancy, and it's the key to this whole segment. Jeffrey Epstein was not technically a fugitive.
And that's because of the 2008 plea deal. So now we're looking at Source 10, the non-prosecution agreement, the NPA.
The NPA. This document is the root cause of the international failure. It's the original sin, bureaucratically speaking. By signing this deal, the U.S. Attorney's Office in Miami agreed not to prosecute Epstein federally.
In exchange, he pleaded guilty to state charges in Florida, soliciting a minor.
Correct. He served his time, what there was of it, he went on probation, and he registered as a sex offender.
Yeah.
From the state of Florida's perspective, he was complying with their terms.
But the crucial part, the part that impacts everything globally, is that the federal investigation was formally closed.
Closed is the operative word. An Interpol Red Notice is almost always generated by a country's federal law enforcement. In the U.S., that's the National Central Bureau, which is a division of the DOJ.
And they act based on what?
An active federal warrant, or an active federal investigation. Because the NPA shut down the federal probe, there was no active file on an agent's desk in Washington or Miami that would trigger that kind of alert.
So the National Central Bureau can't just issue a red notice for a private citizen who isn't currently sought by the federal government.
They cannot. Their hands are tied. He wasn't a fugitive from federal justice. He was a convicted state-level offender who was, by the letter of the law, fulfilling the terms of his sentence.
So the DOJ report confirms this. It shows that despite his conviction requiring sex offender registration, SORNA compliance, that data point did not migrate to the Interpol database.
It couldn't. It stayed in the domestic silo. Think of it like two different computer systems that don't talk to each other. You have the U.S. Domestic Sex Offender Registry, and then you have the Interpol Global Fugitive Database.
And there's no automatic bridge between them.
Not without a federal trigger. So a border agent in France or the UK scanning his passport sees a U.S. citizen with a valid passport.
Yeah.
That's it. They don't see Florida sex offender tier 3 unless they have direct, real-time access to U.S. internal databases.
Right.
Which, they generally do not.
The DOJ report uses very specific language. It says the NPA effectively precluded further federal action.
Precluded. It's a legal term that means it made it impossible. The agreement essentially immunized him from the international alert system that is designed for this exact purpose.
This moves us directly to the physical reality of his movement. The bureaucracy created the opening, so let's look at how he walked right through it. We're referencing Source 7, the Epstein flight logs, and we're cross-referencing them with the Customs and Border Patrol records that are cited in the DOJ report.
But we're focusing specifically on the logs for aircraft N908JE. This was the primary jet during this period. The media called it the Lolita Express, but in the documents, it's just a tail number, an asset moving across borders.
I'm looking at the entries post-2008 after the conviction. The volume of travel is It's significant. We're not talking one or two trips.
No, it's constant.
We have repeated flights to Paris, specifically to Le Bourget Airport. We have dozens of flights to the U.S. Virgin Islands, to his private island, and we have flights to various other Caribbean nations. This is not the travel pattern of a man in hiding or one who's restricted.
And we have to cross-check this with the Customs and Border Patrol records mentioned in the DOJ report. The audit of these records shows a pattern that is deeply disturbing from a law enforcement perspective. Epstein clears customs repeatedly.
The documents indicate he cleared customs in France and multiple Caribbean jurisdictions without detention.
And, critically, without secondary screening. That's the key metric.
Okay, let's unpack that. There's meant to be a notification gap, right? Under the International Megan's Law, IMEA, there's a requirement for registered sex offenders to notify the U.S. Marshals 21 days before any international travel.
Yes, that law was strengthened significantly in 2016 and later. Eventually, they started putting visual markers on passports for certain offenders. But back in that 2008 to, say, 2015 window, the enforcement was, let's call it spotty.
But the DOJ report points out something more specific. Epstein was a Tier 3 sex offender in New York. That is the highest risk classification.
The highest there is. It's reserved for individuals deemed most likely to reoffend.
So even without perfect IMEA enforcement, a Tier 3 status should absolutely generate a flag in the Customs and Border Protection System when he re-enters the country.
It should. It must. The CBP system, Texas, has access to the NCIC, the National Crime Information Center database. Epstein's registration status, his Tier 3 status, was in NCIC, so when his passport was scanned upon re-entry to the U.S. at Teterboro or Palm Beach, that screen should have lit up like a Christmas tree.
But the DOJ report says he was, and I'm quoting, treated as a standard traveler.
That's the phrase used in the internal audit, standard traveler. It implies one of two things. Either the officers at the booth didn't see a flag, which would be a catastrophic IT failure, or, and this is the more likely failure analysis, the flag appeared, but there were no standing orders attached to it.
What do you mean by standing orders?
An order to detain, an order for mandatory secondary screening, an instruction to notify the Marshal Service. But remember, he wasn't a fugitive. He was technically allowed to travel. So the officer sees the flag, sees no instruction to act, and what does he do? He stamps the passport and waves him through.
This validates the testimony we see in the depositions. I'm looking now at the Ghislaine Maxwell deposition, which is source 2, and also the Johannes Sjoberg deposition.
Sjoberg's testimony is fascinating for what isn't there. She describes the travel to Paris, to the islands. She talks about the logistics, the planning, the hotels, the meals. She does not describe stress at the border.
There's no mention of being pulled aside.
None. She doesn't describe Epstein being pulled into a back room for 3 hours while agents call Washington. There's no sense of jeopardy or scrutiny at any international checkpoint.
It was seamless.
It was frictionless. The Maxwell deposition corroborates this. The way travel is discussed, it's routine, it's mundane. This confirms that the flag in the database, if it was there at all, was either invisible to the right people or simply ignored by the agents on the ground because there was no actionable directive attached to it.
Speaking of passports, we have to open the file on evidence item 2347.A. This is from the Epstein FBI report source 6, and it's also referenced heavily in the SDNY indictment, which is source 9.
This is one of the most tangible pieces of evidence we have regarding his intent to evade jurisdiction if necessary. It's a physical object that tells a story.
During the July 2019 raid on his Manhattan townhouse, agents opened a locked safe. Inside, along with loose diamonds and piles of cash, was a passport.
An Austrian passport.
Let's read the specifications from the FBI report. It has a photograph of Jeffrey Epstein, a much younger Jeffrey Epstein, but the name is not Jeffrey Epstein.
The name listed is a false identity. The FBI report redacts the specific name in the public release, but confirms it is not his. And the details are interesting. The residence listed on this fraudulent passport is Saudi Arabia.
And the issue date is from the 1980s.
Correct. So by 2019, the passport itself was expired.
So why keep an expired fake passport?
Well, the physical presence of a fraudulent identity document in a locked safe, alongside what are essentially untraceable liquid assets, cash, and diamonds, is a classic flight risk indicator. This is what prosecutors call a go bag.
Let's unpack the Saudi Arabia residence. Why that specific detail? That seems very deliberate.
We don't have a document from Epstein explaining his choice, of course.
Yeah.
But forensic auditors, when they see something like this, they immediately look at extradition treaties.
And Saudi Arabia
Has no extradition treaty with the United States. So listing that as a residence on a false passport, even an expired one, suggests a well-thought-out contingency plan. If the heat ever got too high in the U.S. or Europe, that document was designed to facilitate movement to, or establish a connection with, a non-extradition jurisdiction.
But the key question is, was this passport ever used during the period we're analyzing, post-2008?
And the answer is, we do not have documentation proving this specific Austrian passport was used for travel during the 2008-2019 period. The stamps inside it, according to the SDNY indictment filings, show it was used at some point, but the timeline of that usage is ambiguous in the unsealed records we have access to.
But its existence alone is the problem here.
The existence of the document is a crime in this context,
Yeah.
and the discrepancy lies with the 2008 plea deal. That's source 10 again.
How so?
When you enter a plea agreement and you're put on probation, especially as a sex offender, you're required to disclose all of your assets and all of your identifiers. You surrender your passports.
All of them.
All of them. The fact that he retained this document, a fraudulent Austrian passport, throughout his entire probation period and for the decade that followed, is a clear, unambiguous violation of the 2008 agreement.
Which also points to a failure of probation enforcement. His probation officers in Florida should have done a thorough check.
They should have. If the safe wasn't searched, if the asset disclosure wasn't independently verified, then he was allowed to maintain a break glass in case of emergency kit for 11 years.
It just connects back to this recurring theme of passive enforcement. The system trusted Epstein to self-report his assets, his travel, his documents.
And he did not report the Austrian passport. Therefore, the system did not know it existed until federal agents physically broke into his safe in 2019. It's another data silo.
We mentioned the notification gap earlier, but I want to drill down specifically into the registry gap. This is what we call the Atlantic divide. We're back to source 1, the DOJ report, and we're looking at the fundamental disconnect between U.S. databases and European border control.
This is a data sovereignty issue at its core. The U.S. Sex Offender Registry, SORNA, is a domestic instrument. It's designed for U.S. law enforcement and, to a limited degree, for the U.S. public to access. It is not an open-source API that foreign governments can just plug into their border control systems.
So, to be clear, a border agent at the Gare du Nord in Paris or at Customs in the UK doesn't have a button on their console that says, check U.S. Sex Offender Registry.
Absolutely not.
Mm-hmm.
Unless there's a specific treaty request in place or a specific individual notification sent from the U.S. State Department or the Marshals Service to the host country saying, Person X is arriving on Flight Y, please be advised, that foreign agent is completely blind to the domestic registration status.
And because of the MPA, the non-prosecution agreement, the federal government had already taken the position that they were not actively investigating him.
Consequently, they were not actively notifying foreign partners. The DOJ report is very clear that federal oversight of his international movement was minimal because, from their perspective, the case was considered closed.
This explains the testimony in the Maxwell deposition, source 2. She discusses traveling to London, to Paris, for parties, for business. We see photographs of them at high society events during this period.
The registry, in effect, served as a domestic administrative list. It was a piece of paper in a file cabinet in a police department in West Palm Beach or Manhattan. It was not a digital barrier at the international border. The flag did not follow the passport.
It really validates this concept of data silos. You have the Palm Beach Police Department, who we know from other documents like the Ryder Letter, was extremely concerned about Epstein and his activities.
Deeply concerned. They felt the MPA was a betrayal.
But their jurisdiction stops at the city limits. The Palm Beach police chief cannot populate a French border control database. That requires federal intervention.
And the federal intervention was neutralized by the NPA. It's a perfect loop of non-enforcement.
Let's talk about the French investigation delay. This is a jurisdiction where we know he spent a significant amount of time. We've established he was in Paris frequently. He maintained a substantial residence at 22 Avenue Foch.
A very significant residence in one of the most expensive parts of Paris. This wasn't a hotel room he rented. It was a home staffed and maintained for years.
So the timeline here is critical. He is convicted in the U.S. in 2008. The flight logs show him traveling to Paris repeatedly between 2008 and 2019. When does the French government open an official investigation?
August 23rd, 2019.
August 23rd, 2019. That is weeks after his arrest in New York and just days after his death in custody.
It is a lag of 11 years, an entire decade of activity that went uninvestigated by the local authorities.
Why? French law is aggressive on these issues. Article 113-6 of the French Penal Code allows for the prosecution of crimes committed by French citizens abroad or crimes committed against French citizens, even if the crime happens elsewhere.
Yes, and key associates like Jean-Luc Brunel were French citizens. The jurisdiction existed. The legal capacity to investigate absolutely existed. The void was in the complaint.
Meaning no victim came forward in France?
We do not have documentation of any victims filing formal complaints with the French police prior to the summer of 2019. In practice, for a complex international case involving a foreign national like Epstein, that's what's required to get the ball rolling.
But does a prosecutor really need a victim complaint to open a file if they have credible information from other sources?
Legally, no. But practically, yes. Without a victim coming forward in Paris, or what's called a spontaneous exchange of information from U.S. authorities, the Paris prosecutor's office is going to consider it a foreign matter, an American problem.
Spontaneous exchange of information. That's a formal legal term.
It is. It refers to the official mechanism where one country's intelligence or law enforcement agency proactively tells another, heads up, we have credible evidence that a crime concerning your jurisdiction has been committed or that one of your citizens is at risk.
And the U.S. Department of Justice did not provide that to the French Interior Ministry.
The record shows no such exchange occurred regarding Epstein's sex offender status or any of the allegations involving French nationals until the 2019 SDNY indictment made headlines around the globe. Only then did the French authorities act.
This brings us to the formal mechanism for that exchange. MLATs, Mutual Legal Assistance Treaties. We're looking again at the Epstein plea deal 2008, Source 10, and the full DOJ report, Source 1.
An MLAT is a treaty process for U.S. prosecutors to formally request evidence from a foreign government. It's how you get bank records from Switzerland, or witness interviews from France, or property searches in the U.K. It is the heavy artillery of international cooperation.
Okay, so we've audited the DOJ report and the available FBI files from Source 6. How many MLAT requests were filed by U.S. authorities regarding Jeffrey Epstein between the 2008 conviction and the 2018 reopening of the case?
The documentation shows 0. We do not have documentation of a single MLAT request filed during that period.
Kilo, for a decade.
0. For a man traveling internationally with foreign bank accounts, foreign residences, and foreign associates. And the cause reverts, once again, back to the 2008 non-prosecution agreement.
Let's walk through the logic. To file an MLAT, you need an open, active case.
Correct. You cannot ask a foreign sovereign government to raid a house or subpoena a bank account just out of professional curiosity. The request must be formally attached to an active grand jury investigation, an existing indictment, or an ongoing criminal probe.
And the NPA said?
The NPA explicitly granted federal immunity. It stated that the United States would not prosecute him or his alleged co-conspirators for any of the crimes under investigation. Therefore, there was no case file open at the federal level.
Therefore, no MLAT could be generated.
You can't do it. This created a circular failure. It's a catch-22. Evidence might have existed in France or the UK, evidence that could have potentially nullified the NPA or triggered new charges. But because the NPA existed, U.S. prosecutors were legally prevented from asking foreign governments for that very evidence.
It was a self-sealing vacuum. The state-level registration in Florida, again, did not trigger federal treaty powers. The Palm Beach police chief could not issue an MLAT to France.
Only the Department of Justice can do that. And the DOJ had signed away its right to pursue the case. So Epstein's international mobility wasn't just luck, and it wasn't just because of data silos. It was a structural void, legally enforced by the U.S. government itself.
He was operating in the blind spot created by the jurisdictional gap between state and federal power and between U.S. and foreign power.
And that blind spot was codified in the NPA.
Let's move to another jurisdiction that functioned as a blind spot, but this one is on U.S. soil, the U.S. Virgin Islands. Little St. James?
This location is absolutely critical because it's a U.S. territory. He's under the American flag, but with a unique legal and administrative status.
And to be clear, Epstein was registered as a sex offender in the USVI.
He was. The paperwork was filed. However, we have to look at the monitoring gap. The DOJ report, Source 1, highlights that federal oversight of the territory's sex offender registry enforcement was limited compared to mainland states like New York or Florida.
The SDNY made a very specific argument about this in their 2019 bail memo. That's Source 9.
They did. In 2019, when they were arguing that Epstein was an extreme flight risk and should not be granted bail under any circumstances. The prosecution laid out the case that the USVI had failed to enforce strict reporting. They argued that he used the island as a safe harbor.
The argument in the memo was that the USVI didn't coordinate effectively with mainland databases like NCIC, that it was another data silo, but within the U.S. system.
That was the core of it. The bail memo details that Epstein was able to travel to and from the USVI with relative impunity. He was not checking in with the local authorities with the frequency that would have been required of him in New York.
So the physical isolation of the island.
The physical isolation, combined with what the DOJ characterized as a lax local enforcement environment, meant that Little St. James was effectively his private kingdom. It was a place where the registered sex offender label had almost no practical consequence on his daily life or his ability to come and go.
There are also documents from the House Oversight Epstein files that touch on this. We see legal arguments in the Jane Doe versus USA lawsuits that the federal government itself failed in its duty to ensure that the territories were fully compliant with SORNA standards, specifically regarding Epstein's monitoring.
It just reinforces what we're calling the Swiss cheese enforcement model. The model has holes in it. You have strict laws in Florida. You have strict laws in New York. But if you have a private island residence in a territory with looser enforcement, and you have a U.S. passport that lets you fly to France where they don't see your record,
you can live 90% of your life outside the enforcement grid.
And the records show that's exactly what he did.
Okay, let's synthesize all of this. We have analyzed the documents, we've laid out the DOJ report, the FBI files, the flight logs, the court depositions.
And when you stack them all up, a very clear picture emerges. And it contradicts the popular narrative of a mastermind evading capture through some kind of James Bond supervillain tactics. The reality is far more bureaucratic and, somehow more disturbing.
Fact A. No Interpol Red Notice was ever issued because the federal case was formally closed by the NPA.
Correct. The primary international tool was never deployed.
Fact B. No MLAT requests were sent to foreign governments to gather evidence because the NPA prevented an open federal investigation.
Correct. The primary international investigative tool was holstered.
Fact C. Data silos between the U.S. sex offender registries and European Union border control systems meant his status was invisible to foreign agents.
Correct. There was no data bridge.
And fact D. The USVI provided a domestic safe harbor with limited federal oversight and lax local enforcement.
Unrestricted international and domestic travel was the mathematical result of those four factors. The records prove that Epstein's mobility was not the failure of a single agent falling asleep at the wheel. It was a systemic, structural void created almost entirely by the legal architecture of that 2008 non-prosecution agreement.
And before we conclude, we must address the unknown. What is not in the files?
This is critical. We do not have documentation regarding any intelligence agency intervention, either facilitating his travel or, ordering law enforcement to stand down. We see theories about this frequently online, but in the files, the hard copies we were auditing today, we see only the absence of law enforcement stops.
We see the doors left open.
We see the doors left wide open, but we do not have a signature on a document ordering them to be held open by an intelligence agency. The absence of a red notice is evidence of the MPA's legal power, not necessarily a CIA directive.
Based strictly on the provided sources.
Based strictly on the documents, yes. The NPA explains the silence of the DOJ. The silence of the DOJ explains the silence of Interpol. It's a cascade of inaction, and it all starts in that one office in Miami.
A cascade that allowed a registered Tier 3 sex offender to fly a private Boeing 727 to Paris, to the Middle East, to the Caribbean, for a full decade without a single documented law enforcement interception at any border.
The system wasn't just broken. In his specific case, it was switched off at the source.
So to summarize the findings of this audit, the international enforcement failure was a direct downstream consequence of the domestic legal failure in 2008. The legal shield of the MPA functioned as his own personal, unwritten, global travel visa.
It did. And that Austrian passport, the one sitting in the safe, tells us that Epstein understood that the system might eventually correct itself. He was prepared for the day the loopholes might close.
But for 11 years, they didn't.
They didn't. The system itself provided enough cover that he never had to use the fake name. He never had to make a run for it.
The Austrian passport remains a physical artifact of an intent to evade, sitting in a safe, ready for a scenario that, legally speaking, never materialized because the system itself gave him all the cover he needed.
It's a chilling realization. He didn't need to run because, based on the official records, nobody was casing him.
Join us next time for the private jet network Who Flew Where and Why. We will be breaking down the flight logs name by name.
You have just heard an analysis of the official record. Every claim, name and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.